With the retrial of Karen Reed's case less than a month away, she and her lawyers are bouncing back and forth between federal and state courts, and they're meeting a lot of obstruction.
With Karen Reed's first trial ending with a mistrial, is there any hope for trial number 2? I'm Lainey Law.
And I'm attorney Andrew Myers.
And is there any hope for fairness in trial 2? It seems like things are not looking too good.
Well, fairness, of course, is the goal of the court always, and under the Sixth Amendment of the United States Constitution, the defendant has every right to a fair trial. And what's being argued in the Norfolk County Superior Court in Dedham right now in the Karen Reed case is the defense's motion to dismiss the case for extraordinary, not just normal run-of-the-mill government misconduct, but extraordinary government misconduct. And so we will get to a motion or a petition for habeas corpus that was also brought by Karen Reed and her attorneys in federal court and was argued in the morning. But then after they did that, they had to run back over to Dedham and face the motion to dismiss. And I don't know my objective observation. I think, disagree with me, tell us down in the comments. I don't think things went all that well for the defense. Defense attorney Alan Jackson was backing up his claim of extraordinary government misconduct, pointing to the intentional failure to disclose key video evidence by the state, by the prosecutors, including that now famous inverted backwards Sally Port video of Karen Reed's Lexus.
You cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure.
Oh, wait a minute, Mr. Jackson. You're going to see that they do deny it. At least they claim that they have some plausible deniability.
And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. While they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence.
Lainey, do you see someone we both know in the front seat there? Mark Bederow, attorney Mark Bederow. Now, as you know, Karen Reed's attorneys have filed a motion to allow him in pro hoc vice, and Judge Cannone balked and said, I want more information. So that more information has, by the way, now been filed by a supplemental motion that was signed by David Yannetti. But Mark Bederow has still not been allowed in to the case. And so there he is. He's sitting next to Karen Reed's parents to our left, screen left, and her brother, screen right. So he wasn't allowed in the case yet. Remains to be seen whether he'll be allowed in, but there he is in the front row.
She's going to get her more info, and the more info is she's going to see our YouTube videos and be like, She's going to see us talking to him, and she's going to be like, nope.
He's very knowledgeable. He knows the facts better than pretty much anybody else on the face of the planet. He's very knowledgeable. We learned how articulate he is as a guest here, but there he is sitting in the audience, you know.
And both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? Other material facts that are not in dispute. The Sally Port video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024.
That is the meat of their allegations, that this video has been in existence since the day that John O'Keefe passed away, you know, way back in January of 2022. And the prosecution didn't even make it known until the trial, the first trial. And that's, not only was the pre-existing video not disclosed by prosecutors until trial, the fact that the video was released all of the video has been released, as they say in their motion, in dribs and drabs. That fact was substantiated by even the newer revelations by the Commonwealth only 4 days before this hearing.
Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick, dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time, I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior sally port. Exterior sally port. That means that the Massachusetts State Police not only had in their possession exterior sally port video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 2025. And they've now admitted that.
I find that very difficult to understand how, Proctor and the others are passing these thumb drives around like we all have. I have a drawer full of them. Hopefully I label most of them, but they're passing around these thumb drives, and there's video on there that they never even disclosed to the defense until after trial.
Well, my question is, I guess to you, and this might be a little repetitive maybe for people who've been watching our channel for a while, is it's not normal, correct me if I'm wrong, or tell me your experience, it's not really normal to be continuing to introduce more evidence into court once discovery is done. But then also it's weird that they didn't have to share it immediately. Like, one, it's weird that I came in the middle of court, and then two, that they had their time with it.
Well, you're absolutely right. It's totally unusual. I mean, you're supposed to have all of this evidence way before the trial starts. And I'm going to tell you in 1 second about how the Commonwealth, certified that they were all done before this stuff came out. And in fairness, I guess, in fairness to Special Prosecutor Hank Brennan, his contention, which we'll get to in a few minutes, his contention is, oh, well, we didn't know this Sally Port video was important. They never asked for it, even though Karen Reed's attorneys, 3 days after John O'Keefe perished, 3 days later, they filed for a protective order to protect all evidence. And the Lexus, Karen Reed's Lexus, was what the Commonwealth was contending was the M weapon. It was the instrumentality that caused the death of John O'Keefe. But Mr. Brennan is saying, oh, well, they never it's exculpatory evidence in that it is the weapon, the instrumentality of the crime here. So for him to argue that, well, I'll let our viewers decide. We get some really nasty comments for people that are on the inside of this case, and they won't. I've asked them, come on. I get a lot of comments and phone calls from people associated with the defense, and I've welcomed the people in the prosecution. But to get back to your point, as Jackson pointed out, the Commonwealth certified that they had completed their discovery obligations just before the first trial. But Judge Cannone interrupted him and said, well, how is that exculpatory or prejudicial? Come on now, Mr. Jackson.
On April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the sally port. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to, yes, I will get to the prejudice as I move through
now
my
or no?
In other words, Mr. Jackson, I mean, come on now. They didn't give you all the really important evidence. How does that prejudice you? How is that exculpatory? Amazing that the question was even asked. And I've been really restrained in what I've said.
If you can, if you're going to do it later, that's fine.
I will do it later. I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided.
Okay. Mr. Jackson also kind of shook his head that the Commonwealth Special Prosecutor Hank Brennan actually tried to turn that inverted video back on the defense as though it was their fault.
Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchanan with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth, during this debacle, had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchanan under direct examination by Mr. Lally. Going into the next day, still under direct examination by Mr. Lally, they played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image.
Oh, mirror image, backwards, inverted, whatever. Do you remember the Han Solo line? Did you see Star Wars or Empire Strikes Back?
Not long enough to quote it.
Okay, well, I think I saw Empire Strikes Back 12 times. And after that, when I knew every line before. Anyhow, it's not my fault. That was Han Solo's famous line. It's not my fault. Well, if there was, in fact, withholding of evidence by law enforcement, Special Prosecutor Hank Brennan was saying, it's not my fault. It was the fault of law enforcement officers, and it wasn't the fault of the prosecutors.
In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area.
I find that really hard to believe. I don't know. I just find that really hard to believe. Brennan continued the narrative of the undisclosed videos, saying that it was Sergeant Yuri Buchanan and Trooper. You know, they're throwing Mr. Trooper Michael Proctor under the bus as much as they can because he's always damaged goods. So what Hank Brennan is saying is, oh, it's not the prosecution's fault. We're all golden. It was Buchanan and Proctor who were passing around thumb drives and didn't let us know.
Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Mechanic went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Mechanic's name, and Trooper Mechanic wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sallyport video, but did not provide it to the prosecutors.
I have a hard time believing that when you have a trial, you have a plan. You have a trial plan, and you have every witness, every piece of evidence, every exhibit. You have it all mapped out. And this piece of evidence, this inverted backwards mirror image of the Lexus, of Karen Reed's Lexus, which is a key thing. It's the instrumentality, allegedly by the prosecutors, of death of John O'Keefe. This had to have been seen as a key piece of evidence, and it had to go into the trial plan. You have a trial plan. You have it all over this conference room table, or you have it on a computer. Somehow you have it organized. So for them to then later say, "Oh, well, they were running around with these thumb drives," and well, we lawyers, we're just the lawyers drinking our lattes. I find that really hard to believe.
Even beyond that, what is the whole point of the prosecution if to not bring the police's their whole case to light? They're saying well, that was on them. That was them doing whatever. And it's well, this is the foundation of reasonable doubt, because if you're telling me that you can't even trust the cops that you've had, that your whole case is built off of, what are we talking about?
Well, yeah, I always assumed, I don't know, because I've never worked as a prosecutor, and I've never been a police officer. I've known police officers. I've represented police officers. And I've known prosecutors and worked with prosecutors on the opposite side of a case. But I would think that it is the police that have the evidence, and they would be running it all by the prosecutors, whether the prosecutors want to use it or how they want to use it or when they want to use it or how they want to, what context that's all trial strategy. But I don't want to use the term legal malpractice. I don't want to go quite that far, but for, police not to be showing a prosecuting attorney everything that they have, and for a prosecuting attorney not to be asking the police, "What do you have?" Now, did we see that car? The car is a key piece of evidence. It's a key piece of evidence. And for them to not even ask, I don't find it credible.
Well, it's not even that's the thing, is for them to not even ask. I think a big thing that we've talked about here on this channel in the past is that when you're collecting evidence for trial, you're collecting all the evidence, whether it helps you or hurts you. You are putting everything out there. So for this to be in existence and for it to have not come to light, but it was still known that somebody knew that it existed, whoever was handling it, that's red flag, in my opinion.
And prejudice is clear and obvious in a case where evidence of this magnitude, again, it took 2 days. The officers were in the stand for 2 days talking about it. So for a piece of evidence of this magnitude not to be disclosed until mid-trial, there's clearly prejudice, because as we saw Alan Jackson, and he said it much more articulately than I am, but as he pointed out, to not have this evidence in advance in order to think it through, digest it, and to prepare cross-examine, that's clear prejudice. It's really clear. I didn't finish up this. I'm sorry, Hank. I didn't finish up your first quote.
Both of those videos remain dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified or was asked about video and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
All right. Well, that's the explanation. Now, there's a totally separate issue that was brought up through the motion to dismiss. It was in large part redacted from the defense motion to dismiss. Let's go to it right now. Remember when we went over this redacted motion to dismiss for extraordinary governmental misconduct and the comment that you made when you saw all the stuff that was blacked out?
Mm-hmm.
Well, this is their motion to dismiss for extraordinary governmental misconduct. And I remember we got to about this page here. Remember this? Dismissal is the only appropriate remedy for the violation of Ms. Reed's Sixth Amendment right to trial by an impartial jury. Additionally, dismissal of this case is also required to remedy the violation of Ms. Reed's Sixth Amendment right to an impartial jury. Now, that's fundamental. Nobody can even argue. You don't have to go to law school to know that. I think you learn that do they still teach fifth grade civics?
Not to me.
I guess I'm showing my age, but I remember learning this stuff in fifth. But anyhow, but the facts supporting that basic concept, there they are. There they are. And so more jury tampering such as this is presumably prejudicial and triggers a burden on the government to prove that tampering was harmless to the defendant. Well, there had been some allegations that had been made, and when it came up in court, the fur started flying.
Fact. Lieutenant Fanning was not in charge of juror security.
Now, what this is all about is that in the motion, the defense was alluding to Massachusetts State Police Lieutenant John Fanning, a supervising commander who was working out of the Norfolk County District Attorney's Office, and it alleged some jury tampering. That Lieutenant John Fanning's role as overall security was related to the removal of a potentially pro-Karen Reed juror before deliberations. Brennan, well, he took special offense, as you'll see now.
Fact. Lieutenant Fanning did not have control of the jury. Fact. Lieutenant Fanning did not access the jury. Fact. Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact. Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact. At all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror. Fact, no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact, Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact, Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court as is responsible, dutiful, and proper.
All right. Attorney Jackson pointed out that the defense's statements were made based on information that was available to them at that time, and that Attorney Jackson's requested sidebar for an inquiry into the matter was not granted. So how could he know? He said the defense never made allegations about court officers, who, by the way, are totally separate from law enforcement, and never made an enemy of court officers. So Mr. Brennan kind of, was very upset, obviously, and he kind of conflated the issue of Lieutenant Fanning, who's over at the district attorney's office, and he's part of the state police, and the court officers. You see one of them standing right there, and Mr. Brennan kind of turned it into an allegation that the court officers have did something wrong. But they're two totally different things. The court officers are part of the court, they're part of the judicial system, and the state police are part of the executive branch. So it's like apples and oranges, but he tried to pin it all on Jackson, and Jackson just said, look, we had asked for an inquiry and we weren't allowed that. So
do you think that's intentional? Like, do you think that that's how he's perceiving it, or do you think that's how he's do you think he's intentionally trying to mush it all together, or do you think that's
I think he's
genuine?
intentionally trying to mush it all together just to, I think it's fairly clear that Mr. Jackson is not being looked well upon by the court. The court is actually looking at, and hinted in a previous hearing, it's considering his pro hoc vice status in the court. He's a California attorney. He's not a Massachusetts attorney, and he's been reminded of that a number of times. Mr. Jackson, that's not how we do it here in Massachusetts. Even though Attorney Yannetti has stood up for him and said, yeah, it kind of is. So I think that Mr. Brennan is kind of hopping on that, we don't like Alan Jackson train. So anyhow, it was a full day and a half of hearings on the motion to dismiss. I think we all know that it's not going to be allowed. Judge Cannone has made it fairly clear that she's not happy with that argument about the removal of the juror, and she really strongly took the side of Mr. Brennan. So it was a horrible day, I would say. I don't know. In my estimation, the defense scored incredibly good points, but at the same time, I don't think that the points were really taken well by the court. That's just my observation. So now you might ask, wait a minute, on the same day, didn't they also have that habeas corpus hearing over in the federal court? Yes, they did. And I actually wanted to go. I mean, I'm a member of the federal bar in Massachusetts. I've been in that courthouse. I've done motions in that courthouse. I have a bar card to get into the courthouse. I certainly, any member of the public can, but they have larger courtrooms at the U.S. District Court in Boston than this tiny courtroom out in Dedham in the Norfolk Superior Court. So I wanted to go, but I've been crazy busy. That's why I can't do these 2.5, 3.5 hour, long lives. But anyhow, one of the Boston Herald reporters did go, and I don't want to slur it, Clint McColgan went, and I took what he wrote and kind of rewrote it a little bit, but this is, from the observations of someone that was in that courtroom. And so here's kind of a summary of what happened in the federal court hearing. Karen Reed and her attorneys argued her habeas corpus case in the U.S. District Court in Boston on March 5th, 2025. Reed's appellate attorney, Martin Weinberg, asked the court to order a post-trial voir dire or formal questioning of the Norfolk County Superior Court jurors who heard the case. Weinberg argued that the Superior Court did have the authority to do that, but U.S. District Court Judge Dennis Saylor asked whether that was true. Oh, by the way, why don't we have pictures? Why don't we have video? Federal courts don't allow cameras. Federal courts.
That's weird that they don't.
No, they're very adamant about it. And arguments can and have been made both. That's why they still have those courtroom artists. I don't know if you read the paper or see some creators show these courtroom artists draw it all. But yeah, during the entire Whitey Bulger trial, which at that point was the trial of the century, and Hank Brennan was Whitey's defense attorney. All we saw in the newspaper was these courtroom artist sketches. But anyhow, so Weinberg admitted that he knew of no direct precedent, but cited similar state cases involving biased juries, arguing that constitutional double jeopardy protections are as valuable. He also brought up a jury bias probe in the case of Boston Marathon bomber Dzhokhar Tsarnaev's 2015 trial. Saylor did not appear convinced. But in Tsarnaev, that's the federal court examining its own case. In this case, that would be the federal court examining a state case. And constitutional law scholars will tell you that's a no-no. Weinberg also argued that Cannone declared a mistrial without consulting with defense counsel, as she was required to do. He said she could have asked the jurors if the impasse was to all charges or only certain charges. Norfolk Assistant District Attorney Caleb Schillinger said Cannone, quote, did not rush to a mistrial, unquote, but instead followed the state law standards. Upon the first and second impasse notes, he said, she ordered the jury back to deliberations. Finally, she declared a mistrial. Schillinger claimed Judge Cannone handled it properly, that to go further could have opened her up to allegations of coercion of the jury. Quote, the jury had made it clear and the judge found it clear that they wouldn't consent to continue deliberating, Schillinger said. And Judge Saylor kind of, to close this whole discussion off, the judge said that if he had a year to write this opinion, I would be more scholarly, but that he was going to come to an opinion as soon as possible so the sides could appeal if needed before Reed's next trial. Now, I don't know about you, but looking at the calendar over on the wall, that's only 3 weeks.
Mm-hmm. Well, also, it's interesting. Like, the thing is just like if they need to appeal, it's just like presumably they're going to appeal. But that's the whole process is just ridiculous and silly to me.
Well, that you say that, or the judge says, give them time to appeal. Wait a minute. Just hold your horses.
What time?
Since when does a federal court decide something of this import in 3 weeks? And then since when do you appeal to the appeal? So there's 2 levels of appeal, but after the U.S. District Court, there's the Court of Appeals, and then there's the U.S. Supreme Court, and they don't act in 3 weeks. I think even a first-year law student on the first day of law school will tell you that those appeals don't happen that quickly. So I
Can't
don't
even
know.
get any customer service within 3 weeks in most.
It just, it doesn't happen that quickly. And but by saying I want to give them time to appeal, doesn't that kind of tell you what he's going to do with it? That he's going to say,
It's like, I'm going to give you time to appeal so I can throw that in the trash too.
And I always say, don't gauge it. Don't. People ask me, well, how do you think that hearing went? My clients always say, how do you think that hearing went? What didn't the judge seem like she was for us, or didn't the judge seem like he was against us? And I always tell my clients and others who ask me, what are our chances? You can't really tell by the demeanor of a judge in the court because they have a poker face, or to appear fair, they will be much more difficult on the side they favor, just so they aren't accused of bias. So you really can't tell. But at the same time, by telling him that he wants to decide it so that they have time to appeal, that kind of sort of, in a way, says, yeah, you're not getting too far in this court. Also, his argument that Attorney Weinberg was arguing for the federal court to intervene in the state court, and the state court's standards for reviewing their own jury verdicts, the standards, the laws, the case law, the statutes, and the rules are totally different in state and federal court. Even though they're only separated by, a few miles, they're miles apart when it comes to the rules. But so anyhow, that's basically what happened. There was one other little development. Well, I won't say little, but the state's proposed dog bite expert, Dr. Crosby, actually PhD Crosby. Remember him? They had a hearing with regard to whether or not he should testify with regard to the marks on John O'Keefe's arm, and Alan Jackson, Karen Reed's articulate defense attorney, had pointed out that the judge herself said, in order to prove causation, you have to be a medical doctor. And so Alan Jackson and David Yannetti articulately argued that this guy is not a medical doctor. So Judge Cannone, by your own standards, he should not be allowed to testify. Well, guess what happened? She said, yeah, he can testify. She said that it is not a question of admissibility. It is a question of credibility. And so therefore, Dr. Crosby will be allowed to testify in Karen Reed's retrial. So it's going to be a battle of the experts. And even though I've used experts and spent hours preparing the experts, and, when you select an expert, you really need to find somebody that really knows the case and is very credible. I tend to think that jurors discount them both. I mean, if expert A says that I think it's a dog bite and expert B says I think it's not a dog bite, my gut tells me that under the theory of juror nullification, jurors say, forget the experts. What kind of evidence do we have here? What is the evidence? So that's just my thought. Just I would ask our commenters to let us know what you think about that. Whether you, if you were on a jury, do you really listen to the experts with their PhDs and all the rest?
An expert is helpful if there's one expert that's saying one thing that can give the jury perspective, but if there's two experts going against each other, then what's the point of even having an expert in the first place? But on a similar note to that, how you asked for what the viewers are thinking if you were on a jury, what, like, would you listen to the experts? I got some comments from our viewers here, and we're going to go take a look at those. These are from our last video on the Karen Reed case. So starting off with Fact Finder Lady, this interaction I thought was interesting. It's ridiculous to think that the ARCA is going to risk their reputation for Karen Reed. Of course, they invoiced for their professional experts. Does any of us work and travel for free? And their license.
Nope.
Yeah, literally. Their license code of ethics for engineers includes to not use misleading tactics. These are professionals that feed their families and careers. So thank you, Fact Finder Lady and LHR 8833. I thought those are interesting comments and good insight.
Yeah, and they reached all of their conclusions and opinions way before they had any contact at all with either side in the Karen Reed case. They looked at the evidence that they looked at. They had their discussions. There were 3 of them. They went back and forth, and they reached their final conclusions, which were written into a report that if they had changed anything based on their discussions with David Yannetti and Alan Jackson and Elizabeth Little, they would have been cross-examined. So in my mind, that's the real point. In my mind, that's the real point, that all of their opinions and conclusions, which they ended up, 2 of them talking to the jury about, had nothing to do with this case.
All right. And I'll let you take over this one.
All Brennan, and people call, that's not nice. I ask people not to do the name calling thing. We don't like the auntie thing. We don't like the hanky thing. We don't, but anyhow, they call Mr. Brennan because in one of his own motions, somebody forgot to proofread it. And, his name had too many E's in it. But anyhow, having said all that, all Mr. Brennan says is just trust me, bro, without any receipts.
There's something healing about hearing you say, trust me, bro.
Just trust me, bro. Isn't that what they said? Just trust me, bro. And then plays about my cat. Okay. Brennan's accusations of misconduct should have been put in a formal motion. Yeah, I agree. That should have been in writing. It should have been a motion. It should have been an affidavit. There should have been some writing. I would agree about that. And then the final comment is Lise Ka, and he is the least trustworthy attorney I have ever witnessed. All right. Okay. All right.
70 Micron Full Melt says, this is next level insane, intentionally disingenuous and abjectly deceitful from Hank. A prosecutor with integrity or ethics morals would never have done this and gone this absurdly long. And only in this corrupt court could this still not only be continuing but getting worse. Egregious and disgusting. Thank you for covering this. I feel like this will be a historic corruption case. Thank you, 70, for the comment. And everybody has their opinions. Obviously Andrew works with the court, so we want to be respectful to them too, but a lot of people have had serious concerns with this case, so it's definitely understandable where you're coming from.
Yeah, we get a lot of comments. We get a lot of them. Train 444 says the judge making sure Karen gets a fair trial, not a concern for the Commonwealth. Having the gatekeeper decide this makes no sense. She's the problem. All right. Again, we get a lot of comments like that. We welcome all comments.
And our last comment from Custer Crazy Horse 8616. Can you truly make a deliberate mistake? If the Norfolk County judicial system, if it's the prosecution's deliberately mistaken, Judge Cannone allows. However, if it's the defense gets accused by the prosecution for anything, the judge immediately has grave concerns. The way Judge Cannone has steered this case, she has had no concern at all in finding out how John O'Keefe made it to his grave, just that the defense can't present their version in their opinion, the truth of what happened. And I think that's something that people have been pointing out a lot, where it feels like the state messes up and it's like, okay, they get a pass, but then anything that the defense does, they're the bad guys.
Yep. So let's ask our viewers the question at the end of the show this week will be, do you think this trial will go as scheduled on April 1st? It's been scheduled for April 1st. The judge has been very firm on her statements that she wants to get it to start on April 1st. My opinion was that if I were the judge, I'd want to get this off my docket as quickly as possible and I'd get it started. But there's just so many issues. Not that I have any inkling that the motion to dismiss is going to be granted, but, the matter that is pending in the federal court, the motion for habeas corpus, just been so many filings. There have been so many motions that have been brought in. It just seems like, they're going to be meeting, 2-3 days a week up to the trial. So do you think that this trial will go forward as scheduled now? That's my question. Do you have any questions for our viewers?
I have a request that if you made it this far, that you leave a little sunshine emoji. As far as my own opinion, obviously comment down below before you let my opinion sway you. I think the trial is going to go as planned, actually on time, and it's going to go a lot faster than we ever expected, and probably then another mistrial. Who knows? We'll see. We'll see you guys for court case number 3. So
Yeah, I'm not Albert Einstein, but he did say that only a fool thing. This isn't the exact quote, but something to the effect that it's really insane to do something and expect a different result every time you're just doing the same thing. So it's hard pressed for me to understand. I think the fact that Mr. Brennan has been just so aggressive, going after all of the witnesses and now going after the attorneys themselves, I think that says that there's nothing new in his case. He doesn't have a case. The Commonwealth's case is flimsy. Now, I'm not going all the way down the conspiracy theory ally, but I am thinking, if Mr. Brennan has a new case, he hasn't said anything about it. Now, the only thing really new, several things, but the only thing that stands out to me is even partially kind of substantive is the fact that he has this new dog bite expert, Crosby. But, again, as I said before, as much money as I've seen spent in my office on experts and as much time that we spent on experts, my gut feeling is the jurors just say, if you have, one expert saying black and another expert saying white, it's out with the wash. And so that's my thought. Okay. Thank you, folks. Do you have any closing thoughts, Lainey?
no, thank you guys. Remember to be kind, and we'll see you at the grocery store.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.